turn our attention to the third case on this morning's docket, cases number 113097 and 113292, the Elaine Ellis Living Trust et al. V. the Harvey D. Ellis Living Trust et al.
May it please the court, my name is Sarah Warner, and I represent the appellants in this matter, the Elaine Ellis Living Trust and its beneficiaries. And I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
This case presents the court with two important and independent legal questions, one concerning statutory interpretation and one concerning punitive damages. But the underlying facts are not in dispute. In the 90s, Elaine Ellis set up a testamentary trust for the benefit of her sons and grandchildren. And then when Elaine died in 2007, her husband, Dr. Ellis, became trustee of that trust. And then things went south. Over the course of 4.5 years through multiple transactions, Dr. Ellis embezzled and converted more than $1.5 million from Elaine's trust in the form of cash and bonds. He also concealed the existence of that trust from its beneficiaries and, of course, his embezzlement until he died in 2011.
Did he have any legal obligation to disclose the trust to the beneficiary, other beneficiaries besides himself?
He did. Did.
What is that? Your authority for that? Since the other beneficiaries were of issue, isn't there an exception under that circumstance under the UTC?
I'm not aware of any exception to it, and I don't believe that it was brought
discussed up. So yes. What is your authority that he did have a duty to disclose the?
I believe it's under Article 5 of the UTC, and I can find the specific provision, but it's under Article 5, which discusses the duties of the trustee.
And I only ask that because it may make a difference if he was truly hiding it when he had a duty to disclose. So.
Right. Regardless, the facts are clear that he did not disclose the existence of the trust. And in fact, the first time that the beneficiaries learned of the existence of the trust was in the months after Dr. Ellis's death. So this went to a trial below, and the district court entered judgment as a matter of law, finding that the evidence conclusively demonstrated that Dr. Ellis committed a breach of trust by embezzling and knowingly converting more than $1.5 million from Elaine's trust while he served as its trustee. And that finding is not before this court. It has not been appealed. Instead, appellants bring to this court two purely legal questions that deal with pretrial rulings of the district court that the Court of Appeals wrongly affirmed. The first is the lower court's refusal to give effect to the plain language of KSA 58A1002. This statute defines the compensation to injured beneficiaries who have suffered a breach of trust. And by declining to give effect to that statute, the courts below have denied appellants the compensation that they're due under Kansas law. And then the second issue that we bring to the court is the decision for the first time in Kansas history that punitive damages are categorically unavailable as a matter of law after a wrongdoer dies. We ask that both of these erroneous rulings be reversed. Now, it's our position that these two rulings are independent legal issues that this court must decide separately. The Court of Appeals, however, switched the order of those two issues, decided the punitive damages question first, and then used its decision on punitive damages to inform its interpretation of the statute, instead of focusing on the language of the statute itself. This, I believe, is an error, and for that reason, I'd like to start with statutory interpretation and the interpretation of, in particular, KSA 58A1002 today. That statute unambiguously defines the damages for breach of trust as the greater of three calculations that are listed in A1, A2, and A3. A1 has to do with putting the trust in the position that it would have been but for the breach. A2 is disgorgement of profits. And A3 is the particular provision that we're talking about here today, which sets a baseline for recovery at twice the value of the amount taken from the trust. There's no question that in this particular case, the greater recovery would be gained through A3 in this case, which of course sets that floor for damages. That's not always going to be the case, however. For example, there could be an instance where a trustee converts, say, some shares of Ford stock, and over the course of that embezzlement period, that stock increases fivefold in value. Now, in that case, the damages that would be paid to the trust would be that fivefold recovery. It wouldn't be the twofold floor that's found in A3. Likewise, if a trustee, say, converted cash and then invested that cash in the same kind of investment and received that same kind of recovery, then the greater recovery would be under A2, disgorgement of profits. It wouldn't be under A3. And so this notion that A3 is somehow different than the other provisions or should be treated differently, as the Court of Appeals and District Court did in this case, I think is a bit of a red herring. Instead, it merely sets the floor for recovery. And in particular, if you remove any of those provisions from the statutory framework that the legislature has defined in 1002, then you do violence to the statute, right? Because you've taken away the legislature's ability to define the appropriate compensation due to an injured beneficiary after a breach of trust.
Can we talk about the money we're talking about? The verdict was $126,820.94, but that was in addition to what had been transferred before, right? Which
That's
was
correct.
$1,435,000. So we have a little bit more than $1.5 million that they got, and they're asking for another $1.5 million. Is that what we're talking about?
That I'll just with one quick note, and that is that they haven't actually received the $126,000. There's been a judgment for that amount. They haven't received that amount. But yes, that's true. The statute says twice the value or double the value of the amount taken. And so the amount taken in this case, as the jury found, is about $1,548,000, something along those lines. So just over $1.5 million.
If we adopt that, your position on this, do we have to overrule our case law interpreting KSA 591704 that has the similar language in?
I don't necessarily think so. Although I will say that I don't know that case law can be read harmoniously or be reconciled with some of this court's later cases regarding accumulative damages. But I don't think so. And the reason is that 1002 sets up a framework for the recovery of damages, whereas 59-1704 is a standalone statute. So they're different. Although the language of those two provisions of 1704 and 1002A3 are undoubtedly very similar, the statutory framework in which they find themselves are very different. And so 1002A3 is part of that structure that says that the measure of damages is the greater of one of these three things, and it's part of that list. The other thing that makes A3 interesting and different from 1704 is that at the time that the legislature took that language and put it into the Kansas Trust Code in 2003, at that same time, they also adopted a different provision from the Uniform Trust Code, which is in 1002C, which differentiates the damages that are set forth in that statute from punitive damages. And so the legislature has said that this is something that is to be treated differently from punitive damages. I would also say that, of course, at the time that statutory language was adopted, there had been no decision of this court that would have said, or of any court that would have said that these kind of damages are not available after a trustee or after a wrongdoer has passed away. In fact, it would be very difficult to read that kind of intent into the Kansas Uniform Trust Code when 1005 specifically contemplates that an action can be brought after the death of a trustee, and then just 3 sections previously defines the damages for a trustee's breach, including Section A3. But, and I think that point is important. The fact that the Kansas Uniform Trust Code actually includes 3 provisions other than Section A3 that help inform this discussion. The first, as we just discussed, is Section 1002C, which specifically states that the damages that are defined in Section 1002 do not preclude an award of punitive damages. In other words, the legislature has said that there is something different about the damages that we're talking about here, which are damages that are due to injured trustees who have been harmed by a breach of trust, and punitive damages themselves. So these are not something that are punitive in nature. And
I'm just going to ask counsel, it basically is a double damage provision in A3, and then on top of that, you can seek punitive damages, correct?
I would change the way that you have structured that. I don't think that it's a double damage provision. What it is it's a damage provision that is defined as a baseline of twice the value of the amount taken. So the damages themselves are twice the value of the amount taken. It's not like you find damages and then you double them. So the legislature has actually defined damages in such a way.
On
that
that
is set
point,
forth
how
in
does
the
how does that work practically in the court? How does that doubling happen? Does it happen when the jury renders its verdict, or is it a post-verdict doubling?
I would think that it would be a post-verdict doubling. I think that there would be a special question to the jury that said, what's the value of the amount that's taken?
And then the judge would look at the statute and apply the legislatively crafted post-judgment adjustment.
I think that's true. I think that's true.
So it's really not a measure of damages.
Well, it's a measure of damages in that the statute has defined that measure of damages. The legislature has defined that measure of damages, and it's a measure of damages in that the jury, I would say, would not just have to find what's the value of the amount taken, but also, to the extent that these questions are relevant, what is the value that would be taken to make the trust whole again, right? And then also what profits has the trustee made, and then there has to be some comparison of those 3 as to which of those 3 numbers would afford the greater recovery.
But I
and
think
that
the
would be
question then,
damage.
is that a jury question or is that the judge?
I think that the legal question, that is the damages that are awarded, is the greater of those 3 things.
But there
is
could
going to be
some dispute on when you compare those, which, I mean, I don't know that would always be definitive. And if there's a dispute about which measure of damages is greater, is that a jury question, or does the judge make that decision?
I would think that the jury would actually make the determination as to finding the damage amounts or finding those values, and then the judge would make the ultimate determination as to which of those is going to be greater.
The opposite of a damage cap in some ways.
That's correct. And these exist elsewhere in Kansas law, and this court has found that those kind of damage provisions are compensatory in nature. For example, under the Kansas Consumer Protection Act, there are alternative damages of either actual damages or some statutory amount, and the court has found that even that statutory amount, even at $10,000, et cetera, it's still compensatory in nature. So I see that my time is up at
How many
this
did
point.
you say? 3 other provisions?
That's correct.
And the first
three of
one was 1002C. Can you just list the other two quickly for us?
Yes, the other two are 1005C1, which deals with the limitations period for stating a claim, and then the other. I think that there maybe are just two provisions, Your Honor. I think
okay.
I may be miscounted, but and then of course the plain language of Section A itself, that overarching cap that says that is liable for the greater of.
Any further questions? Any further presentation?
Just during my rebuttal. Thank
All
you.
right. Thank you, counsel.
May it please the court, Lee Thompson on behalf of the estate and trust of Dr. Ellis. Kurt Tiedemann is also here for the KU Endowment Association, but I will be presenting the argument. The arguments in this case have consumed, by my last count, 12 briefs, which on the Court of Appeals level and on this level. And I think it's important to maybe, like viewing an impressionist painting, take a step back from all the dots and make sure we understand what the claim here is and what the damages awarded was. The claim is that Dr. Ellis committed a tort, a very specific common law cause of action, a cause of action for conversion or embezzlement or a breach of fiduciary duty. Those are the attributes of what a breach of trust is. The jury was instructed that the plaintiffs should recover whatever damages they need to restore the value of the trust to what it was, but for that conversion. And of course, long before the trial and long before all the arguments and evidence asserting claims and punitive damages against Emprise Bank and against the attorney, the money had been returned by special trustees. I was then appointed as a special trustee, much to my surprise, because I hadn't been asked, but it worked out that way anyway, to represent and defend the trust against the additional claims. We did that, we went to trial, and there was, and I recognize, legal rulings that are central here that did not go to the jury. But what went to the jury was the full range of what the plaintiffs claimed they had been harmed by in terms of the transfer of funds. They claimed $1.7 million. And they had interest and various calculations about the timing of the transfers. The jury heard that, and
Was
the
that,
jury...
excuse me, Counselor, was that 1.7 additional dollars over and above the 1.4 that had been transferred back already?
No, the court instructed that they first get the total amount and then
Okay,
whether
so
there's a credit.
So that 1.7 would include the amount that was, I guess, conceded and returned.
Yes.
Okay.
Actual damages under their theory would have been in the range of $400,000, I think.
Yeah.
We argue that that was not the proper measure of damages, how they were harmed, what the interest was, and the jury gave full compensation as it determined appropriate in this case of $1 million and $1.5 million, which was about $125,000.
But you all are not here arguing about the difference between 1.4 and 1.7, or the difference between 400,000 and 126,000. You're arguing about doubling that.
Yes, we are.
Okay.
As I said, I was just trying to paint the picture,
Okay.
but I think they are connected because the plaintiff's arguments are that there is a component of cumulative damages in this case, or full measure damages. And they cite antitrust cases, and I'll talk about that later if I have time. But this is not a cumulative damage provision, it's an alternative damage provision. And I heard arguments about the meaning of any and the in the earlier cases. Here we're going to discuss the meaning of or. We have a procedure which says the trustee who commits a breach of trust is liable for, and then it has two things. And then it imposes a different factual scenario upon Section C, a very personal scenario which is keyed to whether the trustee has personally used the funds that had been absconded, transferred, whatever you want to say. They all don't relate to the same conduct. The only conduct addressed by the double damage provision is the personal element of personal use. The trial judge held that Dr. Ellis had not used it personally, and we lost that issue on appeal. As with many things in this case, we are not appealing that. The beneficiaries of Dr. Ellis's trust, KU Endowment, St. Jude Children's Hospital, the Navigators, Dallas Bible Theological Seminary, don't want a penny that doesn't belong to them. They think the plaintiff should get all the results of whatever happened to him. But in this case, what happened is there's a very personal component of personal use, and that's why this statute imposes a penalty on him for his personal use of those funds. If you look at the Uniform Trust Code...
Counsel, can I just, sorry to
Certainly.
interrupt, just so I can clarify in my mind. As I understand your argument, it's that the jury got the universe of decisions that they could have possibly reached, and they reached a decision.
Yes.
Was the jury told that, assuming they made whatever you think the appropriate factual findings are, they could have awarded upwards of $3.4 million or whatever the doubling of the total is?
No, that decision had been made prior to the jury trial as a matter of law, and so it wasn't an issue.
I understand you to say that the decision as a matter of law that took that away from the jury was premised on an issue that you then lost on appeal as to the personal use aspect. Is that right?
Yes.
Okay, so where does that
But that
leave
was
us?
also a legal question.
Right, but where does that leave us? Because we don't have that issue before us.
I think it leaves you with the holding that we have not appealed from, that Dr. Ellis did personally use the funds.
So then we're left with only the rationale of the Court of Appeals.
Yes,
Okay.
which I think is a very good one.
Right, but that's different from what you were just suggesting a minute ago, isn't it?
I don't think so. I'm saying the actual damages that were incurred were litigated and tried. I'm saying there is a penalty for a very unique aspect of the tort, personal use. That has been found, and that penalty would encompass doubling the damages. The actual damages have nothing to do with that penalty.
Counsel, go ahead, well, go ahead.
Well, just real quick, how do we get around subsection C, which seems to make it pretty clear that subsection A, in all its iterations, is not a penalty, but an actual damage provision?
I differ from that. I think it
So help me
results
get
in
there.
a totally different inference. It's superfluous language unless you realize that there is some element of 1, 2, and 3 which might be construed as punitive. If they are all compensatory, if they are all actual damages, then as a matter of law there would be no need to add additional language saying the provisions shall not exclude an award of punitive damages. What happened in this case is you have the Uniform Trust Code. Uniform Trust Code says the amount necessary to compensate fully for the breach are 1 and 2. That's in the Uniform Trust Code. Kansas legislature came along and stuck the double damage provision on this. There's no explanation why. There's no reasoning why, and far be it from me to try and speculate to what the Kansas legislature might mean. But I think it's pretty obvious. It picked the wording up exactly from the probate code and said this is a very unique sort of thing when you personally use the money, and thus you should be penalized. The recorder of the Uniform Acts, Professor English, in the article in the Kansas University Law Review says this is an additional penalty. It mirrors the probate. Every case that has construed that says it's a penalty. It was also called a penalty in the McCabe case by the Court of Appeals, trying to decide whether it was retroactive or not. In McCabe, Court of Appeals just said this is a penalty. Anyone who reads that language says it's a penalty. It is not cumulative. It simply addresses a different set of facts, and thus I think it's important to note that it says the trustee shall be liable for double the value.
Counsel, let me ask you about subsection A3, the double provision. One of the issues is whether you can enforce that provision against a deceased trustee.
That is the key issue, I believe.
And the act allows you to name a deceased trustee going forward. So I'm having trouble trying to figure out why there's this notion of an exclusion with A3. I mean, once the act says you could name a deceased trustee and enforce these provisions, I don't understand why we're talking about deceased versus a live trustee when all of them are subject to this act. Does that make sense?
I understand the question. I disagree that it makes sense, if I may be so bold. The reason
I only cared whether the question made sense. You can have whatever answer you want.
The reason I say that is that the statute says a judicial proceeding may be brought for 2 years after a trustee dies. That's no more than saying a cause of action survives. This is exactly what the survival statute says. Causes of action survive. This cause of action for tort survives. That's why there's a trial on what the damages for this trust, the Lane Ellis Trust, was. It does not preclude, it almost begs the question and assumes the resolution of whether or not the damage is punitive or remedial. The question is not whether the cause of action survives. Admittedly, it survives. The statute says claims can be made, just as the probate statute says claims may be made. But once the cause of action is stated, then you have a different question as to what the remedy is. And the case law of this court, particularly in the Alexander case, which they quote, particularly in the O'Brien case, distinguishes between causes of action and remedies. The remedy is penal in nature. The remedy does not survive, and that gets into the punitive damage issue. I think that's been briefed pretty extensively. I will simply say that I don't quite understand how the inventive Kansas bar of plaintiffs' lawyers for 150 years has never brought that issue before this court before. I'm not trying to be cute, but I do think it speaks of the fact that probably very few people have ever assumed that punitive damages would survive. Punitive damages and penal statutes punish. That's exactly what subsection C is designed to do.
Well, they also
punish.
talk about a deterrent effect.
They do.
And how does that play into the whole punishment aspect? Because a deterrent effect goes beyond just sanctioning the behavior of, in this case, the deceased. It's a deterrent effect on others to not engage in the behavior that led to the punitive damages, isn't it?
I think that is why in the antitrust realm, for example, a separate cause of action was created to provide treble damages. That punishes a community sort of wrong. I think the deterrence here on someone who must think, well, I'm going to die in the future, therefore I shouldn't do this because whoever my beneficiaries are might be punished, is somewhat tenuous, to say the least. I would suggest that clearly, as all Kansas courts, appellate courts have held, this is a punitive nature.
Why isn't it more akin to a liquidated damages provision? Couldn't it be that? Couldn't it be, look, you converted or embezzled this money. Not only was the trust deprived of the value of the money, but was deprived of the time value. And that might be a hard thing to figure out. And 1 and 2 actually seem to indicate that the jury can consider profits and so on. But short of that, we are just going to liquidate the damages at double the amount. Why couldn't that be what the
Because the damages awarded in this case considered time value of money, considered all those ancillary issues. That was a part of the damage package presented to the jury. All of that was decided. The only thing left to decide is a pure mechanical doubling. And I think there might be a question whether liquidated damages against an individual survive also, but that isn't before us.
Well, it almost, to follow up on that, it doesn't say money. It doesn't talk about money in subsection 3. It talks about personal property. And if they had, trustee had converted 1956 Thunderbird or whatever, we're not gonna fight over it, whatever its value is, and then we get double that.
Right.
You know what I'm saying? So
Yes.
that gives more credence to being a measure of damages rather than punitive since it applies to all personal property. And it doesn't say funds. You would think if it was talking about money, it would say funds or cash or whatever. It talks to personal property.
And of course, municipal bonds are personal property. And so that's the value in this case, and I think it does speak to value. Bottom line, I would urge this court to consider whether or not a punitive award survives the death of the wrongdoer, and whether or not this penalty, as construed by the courts for a very unique personal act that would punish the beneficiaries, not the trustee, should also be construed as a cause of action which survives, because only causes of action survive, remedies do not. Thank you.
Do we have any further questions? Thank you, counsel. You reserve 3 minutes for rebuttal.
Thank you, Your Honor. To start off, Justice Lukert, the provision that I was relying on and that I wrongfully said was Article 5 was KSA 58A 813, which is the notice provision. There has been much discussion here about whether Section A3 is a penalty. And I will acknowledge that there are decisions of this court and of the Court of Appeals that summarily discuss that provision, or at least 1704, as a penalty. But I would encourage this court to take a deeper dive than just those surface labels that have been placed previously and take a look and see whether this provision is compensatory in nature. Was it intended to compensate injured beneficiaries? And I would say that a plain reading of the statute will answer that question, yes. This court did a similar analysis in O'Brien in the context of reviewing the Kansas Restraint and Trade Act. And there, the court was called on to look at the types of damages that were available under the KRTA and said that, yes, there are full compensation damages, there are treble damages that are available under that act, and not only that, but those are cumulative, meaning you can get full compensation and treble damages, and yet that act was intended to compensate consumers who had been wronged by the kind of conduct that was directed to under that act. Likewise here, this is a provision that is designed to compensate, if handsomely, although not as handsomely as under the KRTA, injured beneficiaries who have been harmed at the hands of trustees who have embezzled or converted trust property. So although there's been discussion of this as a penalty, I would say that it's not a penalty. It is designed to compensate those individuals.
Would you go back to your earlier discussion about the KCPA and how that is an analog?
Yes. So the KCPA, and this is the Alexander decision of this court, the KCPA allows for alternative remedies, much like in this particular case, there are alternative damage provisions. So under the KCPA, one can receive actual damages, or they can receive an amount of damages that is $10,000 per violation.
And there's also a provision for civil penalties to be imposed, is there not?
There is. And in particular, this court in Alexander differentiated between the civil penalties that could be pursued by the Attorney General's office on the one hand, and then the type of compensation that is available to a private party on the other hand, and said that those compensation types that were available to private parties to compensate for private wrongs, as is the case here, those are compensatory in nature. Even if it's a handsome compensation, it is not intended to punish, it's intended to compensate, much like the liquidated damages provision that Justice Siegel was relating to. I didn't have a chance to talk about punitive damages. Are there any questions about punitive damages before I wrap up?
I see no questions there, counsel.
Okay. So if I may take just a quick second to conclude.
I'll
Your
even
Honor?
give you 30 seconds.
All right, thank you. This case really comes down to statutory interpretation. Both of these issues come down to statutory interpretation, whether you're talking about KSA 58A 102A, C, or KSA 60-3701. The bottom line is that courts are not to read language into statutes that are not there. That's what's happened in both of the decisions below. And so for all of these reasons, we would ask that this court reverse those erroneous decisions and remand to the district court with directions that those statutes be followed. Thank you.
Thank you, counsel. We thank both counsel for your arguments this morning. The court will take this matter under advisement.